would like to thank you all for attending today's webinar. Our topic for today will be on the top issues when considering a data center transaction, colocation services, financial requirements, and contracting SLAs. We are proud to share with you our mix between experience and innovation with our presented content. Each webinar covers a different topic that we believe will be relevant to your day-to-day experience, your strategic planning and operations, as well as your cost effectiveness. We have hosted webinars with multiple topics, including about data center sourcing, cloud economic strategies, battery technologies, and effective operations of a data center. You can find our recorded content when visiting the shown link, www.eypmcfinc.com/videos. Also, don't forget to follow us on LinkedIn. Now, before we start, if you have any questions, please feel free to write them down in the chat room, and we will be answering at the end of this presentation. Also, after answering the questions from the chat room, we will go and open the microphones for you to be able to ask any questions. We would like to welcome our speakers, Kevin Sanders and Jeffrey Mortler. Jeff is the head of the real estate and communications practices in New York for Mintz. During the past 30 years, he has developed a unique specialty practice in the intersection of real estate with technology, communications, and energy issues. He has an extensive experience representing landlords, tenants, and communication service providers in the leasing, purchase, sale, and financing of data centers and switch facilities, colocation facilities, radio and television broadcast antennas, distributed and in-building antenna system, rooftop antennas, and fiber optic transactions, as well as the wiring of buildings for broadband communication access. Jeff has also negotiated thousands of rooftop and cellular antenna leases, inside wiring agreements, antenna tower leases, and data center colocation and switch facility leases throughout the country, covering over 500 million square feet. Jeffrey, it is a great honor to have you as our guest speaker. Our other speaker is Kevin Sanders. Kevin is EYP's managing principal for data center consulting and strategy. Kevin has over 35 years of experience in the planning, design, implementation, and management of data centers, information systems, and network communication systems. As a consultant for the past 25 years, he has worked with many colleges and research universities, healthcare, pharmaceutical, and financial institutions, including from the Fortune 100 list. Kevin is responsible for all client strategic data center consulting work for EYP mission-critical facilities. Kevin spearheaded the use of both financial and technical architectural models to allow clients to understand the cost timeline for infrastructure, technology, and organizational options to assist CIOs, CTOs, and CFOs in the control and predictability of their hybrid IT and data center budgets. Kevin, thank you. Please go ahead with your presentation.
Thanks, David. It always sounds so good when you read those bios. I appreciate it. Let's go to the first slide. Next slide. So when Jeffrey Mortler and I were talking about putting this webinar together and to talk about the sort of issues around contracting and transactions specific to colocation providers, one of the things that became apparent was that a lot of our clients, the ones we had jointly and others that were independent, really had underestimated the sort of task on either end of coming up with alternate data center services. They frequently underestimated the ability to gather the kinds of data that's required in the background, and they did not necessarily understand how that data fed a good contract and how a good contract supports the implementation of an alternate data center source, in this instance a co-location provider, in more ways than just sort of standard terms and conditions. And so we decided to sort of focus on this today to give you a sort of taste for that background. Now, I'm not going to spend a lot of time on data center strategy. If you want to hear that, you can go to the website, as David had indicated, and there is a webinar there on our data center strategy approach. And at the end of this session, there's contact information. Please feel free to get a hold of us if you want to talk about it in detail. But what I am going to talk about today are the elements of a strategy, those pieces that are important, because that data feeds what you will eventually use to support a contract. Normally, you think about a contract simply as a sort of legal terms and conditions, and yet it really is much, much more important to understand that a contract needs to mimic the sort of individual requirements of for a client within the confines of that facility. And over the years, the many, many, many years I've been doing this, one of the things that has become apparent, because we sort of have a unique position in looking at the industry, is that there is a sort of a one-sided approach generally when a client is looking to put a strategy together. We are really fortunate because our group, in addition to the strategy group that I run, EYP is comprised of several other modules, all of which help a client generate a richer set of data points, a richer set of environmental requirements. We have a full engineering background, full integration, meaning ability to stand up and build or help operate. We commission data centers, and we understand advanced energy services. All of those combined for our clients allows us to take a step back and understand how those areas impact a strategy, in that they create information which essentially allows you to select, what it is that you need. Next slide. And so when we're talking about the use of co-location, even if you're engaged in that now, we really are talking about change, and how EYP generally comes to working with its clients is some level of change is going on in that organization. In most cases, particularly in the last couple of years, it's been issues around aging infrastructure and data center consolidation. And usually those are combined, meaning companies have recapitalized many, many years ago and built data centers. They're getting a little long in the tooth right now. They're not supporting the architectures that are required. They are engaged or continuing to work on data center consolidations, both in the continental United States and internationally. And they're looking to find different levels of data center sourcing. And generally the two that are turned to are the use of co-location and the use of cloud, or cloud adoption as we refer to it. And even though they're looked at as independent problems, usually we find right off the bat that clients are looking at these things as stovepipes, as sort of independent issues, and they really can't be looked at as independent issues. They are really flip sides of the same coin. And it's that understanding that if you touch one piece of infrastructure, or you have discussions around IT architecture, that you're going to affect the others. And that common to all of that is a cost structure, meaning how you're delivering the ability to run your application portfolio. That is the sort of the prime goal of this. It's not to have a co-location ability. It's not to have cloud services. It's to run your app portfolio. And in order to do that, you need infrastructure. And infrastructure has a cost associated with it over a period of time. And usually the way to understand that is to understand the particulars in each of these areas. And I'll talk about it in a little bit, but we find that most clients don't ask all the questions in all of these areas. I like to coin the phrase, they don't necessarily do their homework, because there's a lot of hard work here playing essentially forensic investigator, trying to determine what the structures are in each of these areas that you need. Move, next slide. And so for the most part, there's some sort of data center master planning that gets done. To some extent, or to a much, or we refer to as a much lesser extent. Part of it we refer to as the demand side, and then there's the supply side, sort of borrowing from the old economics regime. all too often what we find is that clients rush to the solution alternative. And I understand that. I'm guilty of doing that too. It's sort of much more fun to rush out and start looking at co-location facilities, start talking about how you're going to provide services, talk to cloud adopters, and get into that side of the house and begin to build your business case or your planning requirements there. And I'm often say that that is the wrong end of the stick to start with, that you need to start on the other side, which is the demand side of it, really to understand your capacity. And in terms of co-location contracts and contracting, your capacity capability, what you need over what period of time and how quickly, is the majority of the homework you need to do, because that has profound impact and implications. And we'll refer to that to some quotes a little later. But capacity planning isn't a sense of just adding up everything you have and looking at your existing inventory. In order to understand what you're going to need in the future, you really do have to understand what your capacity requirements are going to be, what your initiatives are going to be, the business side of the house, mergers and acquisitions, growth, changes to the application portfolio, the rate at which you can actually move applications to the cloud. And I know a couple of years ago there was the common statement about everything is going to the cloud, and the cocktail conversation was, we're moving everything to the cloud and we're not going to need data centers. A lot of that was tried and a lot of that boomeranged back. The two things that have become axioms or facts around the use of cloud is, first and foremost, cloud works, no doubt about it. It is a tremendously useful option to your data center sourcing. What also became a fact is that there was a general lack of understanding of how cloud would be employed, what applications could be moved to the cloud. And key to understanding capacity planning and what you need in a physical facility is also understanding the rate at which your app portfolio can move to the cloud. That sort of back and forth has become the essence of a lot of trouble for a lot of folks trying to figure out how much capacity they need to put into a co-location facility, and meaning another data center source, or if they're going to retrofit existing data centers, how much of that do they need to do? How much do they need to spend on renovation? How big does a retrofitted data center need to be? And curiously enough, back to the co-location option, a properly designed contract can allow you to both grow, ramp up, and shrink within certain considerations, so that you're not locked into a fixed capacity capability, and not many people really understand that. But if you've done your planning correctly and you can predict what you need both in growth and potentially in shrinking, or have the right to shrink the footprint without too much penalty, your contract makes it so, but your planning, your forecast gives you the data you need to defend that requirement. There also is this whole issue around resiliencies and tier levels and how much backup and your level of DR. And that's also one of the sort of dirty little secrets that has never been solved in most companies. Most entities will tell you they have some sort of DR capability, and whether or not they've ever exercised it, or if it can be exercised to an accurate level, in many instances is really not known. There's a lot of plans. They may or may not have actually been tested. And there's also a rush to say that I need extremely high tier levels, resiliency levels, and that may or may not be true based on the topology and based on how you manage your app portfolio. And so understanding resiliency as part of your requirement for data center sourcing, and in particular co-location, is important, because oftentimes you can solve both problems at the same time. And one of the more common examples of that is there are certain data center providers that have great relationships with cloud providers and provide high bandwidth link between a co-location facility and a cloud provider. And you can set up enterprise and your own private cloud in that facility, use that network that they have in place, high bandwidth, to the cloud provider, and provide certain amount of DR capability in the public cloud, depending upon security and app requirements, et cetera. Or you can have multiple locations for your requirement. And so what's important to understand is that DR relates to also how much capacity you need, how much co-location you need, what the contract needs to cover you for. And it does you no good if the terms and conditions don't allow you to set up a DR with a modest cost at a modest capability in a facility that will maintain the environment that you need. And then there are non-technical constraints, regulatory, government influences, certifications, as I said, security issues, and some of those are things which are provided by a co-location provider, some of them by a cloud provider also, and also need to be understood well in advance so that they can be put into the contract correctly, particularly those around regulatory. If you have HIPAA requirements or government security requirements, those things need to be understood. Even if you don't have standard regulatory issues, but you want to set up an extremely secure environment, contract is a methodology for ensuring the fact that you have seclusion and isolation and controls around the footprint and around the network connections from your space to the networks. Don't want to go into too much detail. We can at another time, but again, it's another case where those requirements are ensured by a properly designed contract. And as we talked about the solution alternatives, those are actually the easiest part. Once you understand what it is that you need, the three first boxes, figuring out what the solutions are becomes a whole lot easier. Next slide. And so here we're going to talk a little bit about the sort of shortfalls. What's important to understand, again, is that the comments I'm making here are a function of being able to observe dozens and dozens and dozens of given situations over the years, seeing what works and what doesn't work, seeing what client issues are both internally and in the technical evaluations that we do for them and how things are sold, and working very, very closely with co-location providers. And in most cases, I think people think that co-location and cloud are separate items. And it's important to note that they're really part of an overall strategy. And if you're looking at co-location and you have an interest in cloud capability, you need to look at it at the exact same time because, again, what you contract for is going to be affected. It's also important to understand that a strategy demands data. Lacking good data, you are never going to get approval internally. And one of the more frustrating aspects of the work that we do is spending considerable periods of time putting data together as directed by the client, but the client not having done some homework in advance to understand exactly what the threshold to an agreement, to getting to yes internal to their company is. And so the real goal in developing a strategy is both developing it and developing it so that it can be approved internally. And sometimes that means phased approaches. It means managing the operating costs and capital costs over a period of time by phasing it in so that your organization can absorb that cost. And again, one of the ways you do that is through the contract to ensure that you can hit those ramps, you can hit those steps, that phased approach over a period of time. Some other common approach issues are the stovepipe approach. It is sometimes difficult for us to share, and I think organizationally, facilities groups and IT groups grew up separately. They have a tremendous amount of merging, real estate being involved now, but it is really common when I'm working with a client for them to not have made aware the other parties that need to be part of it. In particular, finance, having them come along in the beginning and understanding what the thresholds, as I said previously, to getting the yes is, and what the cash flow analysis needs to look like to sell it internally. It's incredibly important to have legal involved. I hear Jeffrey clapping in the background because they're going to have requirements not just from a standard terms and conditions, but for any third-party issues they have, or any regulatory they're going to make you aware of, or any security issues they need to be involved in the beginning, and they need to understand that this is heading towards a contract that they need to eventually handle. And as Jeffrey will iterate in wonderful detail, co-location contracts are not real estate contracts. They're also not professional services contracts. They're sort of a combination of both. And you have to have that capability to be able to manage that well in advance. And many of the items that you're going to work out when you develop your requirements need to be turned into terms and conditions, and that needs to be known well in advance. Failure to address long-standing problems. My example of DR. If you're going to take this approach, you need to use this data center sourcing capability as a way to solve sort of all the things that need to be taken care of. And by not having a stovepipe approach, and to have multiple stakeholders as part of the process, you're going to discover potentially application development issues, application growth issues, merger and acquisition information, things that are going to influence you in the long run. And I think the biggest problem that I see, because we actually are hired by a lot of clients who have launched a strategy and then hit a wall, and they want us to help them fix that strategy. And what we generally find is the strategy is a huge focus on technology, which is of course important. The IT architecture, of course important. But the plan isn't executable. It's not phased. They haven't worked out simple things like, how am I going to migrate the applications in, and what's the cost going to be? And even with that discussion around migration, again, contract comes into play. How is the provider going to support you while you're migrating applications? How are they prepared to onboard your equipment? Next slide. And so, without giving you too much of an eye chart, and you can find this on the webinar that is on our website, which talks about strategy. There are a lot of building blocks to putting together a good strategy. We talked about a bunch of them: capacity modeling and what your cloud adoption levels would be, a review and assessment of your existing facilities. Whether or not you're going to stay in them, you need to understand them. And we often say that one of the ways you sell a strategy is to make senior management understand what it's going to cost to stay in the given facilities that you have. Coined the phrase, if it's business as usual for the next 5 to 10 years in our existing, with our existing portfolio of facilities, what's that going to look like? And oftentimes that results in a lot of forensic accounting, but in most cases that number is eye-watering and helps you sell the new plan. You see a little thing there from the end called Colocation RFI process. We are big proponents of getting the most accurate data you can, and one of the ways you do that is to issue RFIs, not an RFP, but an RFI in advance as a method of getting good costs from your providers, becoming familiar with who the co-location providers are, having better numbers than just sort of a retail number that you would plug in. It also allows you to get copies of their contracts and understand their normal terms. It starts that whole process, makes you understand what you need to do. It also can become the basis of shortlisting. So if you're in a situation where you're looking at 5 or 6 or 7 potentially providers, it may, I stress may, allow you to limit that to 1, 2, or 3 at the tail end when you issue an RFP. This is also the point in time where you begin to assemble what your contract requirements are going to be, so that that's part of the RFP process. And then the financial analysis. Next slide. And the reason why the financial analysis is so important is it needs to be detailed. It's one of the ways you sell the strategy internally. But in order to get to the financial analysis, and having done the RFI, you're able to begin to plug in costs very early on around your co-location solution, around its length, its time, how the build-out costs are going to be involved, what it would look like, so that when you get to the RFP process, you're in a lot better position than you normally would be. And having an understanding of the cash flow and expense also makes you a better negotiator in terms of those final costs. Next slide. And sort of in summary, when you take a look at the the sort of my top 5 versus Jeffrey's top 10, the issues that are most critical. is the sort of lack of data, really poor data. And I have to tell you that in talking with colocation providers, because we do work with them directly, one of their frustrations, meaning their concerns in being able to work well and provide good solutions for their clients, is clients who come to them, a great majority of them, with a really poor understanding of their needs and strategy. The better you are at coming to them and laying out a forecast of precisely what you need in terms of capacity over time and the special needs that you have around security and third-party assistance and monitoring and management, the better partner they're going to be for you and the better they can be in creating a set of costs for them. Their biggest nightmare is the client who comes to them with the back of the napkin calculations, because they know that that's probably not going to turn out well in the long run. Got to focus on total cost of ownership costs. Again, I want to stress that you can have flexibility, and contracts will allow you to do that. You need to look at what auxiliary services you are, and the security pieces. These are things that generally fall off the end of the the end of the dock. Your IT architecture, need to understand your density and your network requirements in advance. And last but not least, and the way to set up my colleague, Jeffrey, is inability to execute a good contract. I've got to tell you that over the sort of 10 to 15 years that I've been involved in co-location contracts, I have had many well-designed strategies fall off the end of the dock because of an inability of that client's legal staff to execute a contract with the co-location provider. Enormous amount of work, good work done. Even if you can get to a contract, sometimes your lack of understanding of how to do it, meaning what's appropriate in that environment, leads to difficult relationships in the beginning, and that plays out over a period of time. So with that, let's go to the next slide. I want to say thank you. I'm going to turn this over to Jeffrey. If you need to contact us, please do not hesitate to give me a call or send an email, either myself or to David. And as I said, our website has a substantial amount of other additional webinars on it on this topic. So, Jeffrey, I'm going to turn it over to your capable hands.
Thank you very much. Good afternoon, everyone, and I appreciate the opportunity to work with EYP here, as I have on many transactions over the years, and they are a huge value added and make my job easier because they've teed up the transaction properly in advance, and the client knows what it needs, and the counterparty knows what we need. Next slide. So this is my top 10 list, my homage to the late David Letterman show. Next slide. So in terms of what I see in data center transactions, and I did my first data center transaction in 1990 and have been spending a substantial amount of my time on these since then. There's been a sea change over the last 15 years or so, 10 years. Used to be, when I originally was involved in the space, that the data center transaction was led by the real estate department at the client company or their facilities or operations, whatever they called it. Over the last 10 years or so, there's been a major shift. Now, a majority of transactions are not led by the real estate people. They're led by some sort of an IT, technology, telecom group at the client who come at it from a different perspective. Over the last 10 years, the volume of data has grown exponentially and continues to grow, and the importance of that data within the operations of the company as we've all shifted to a much more internet web-based operations and document support and website operations and billing and payment systems and such has dramatically swung this towards IT taking the lead on these transactions. I would say today about 60% of the transactions I do in the data center space, about 2/3 of what I do is representing owner-operator developers of data center facilities, and about 1/3 on the tenant customer side. And in all of these transactions, IT has risen. I'd say about 30% of the time, both IT and, real estate takes the lead about 30% of the time, and about 10% of the time, both IT and real estate are involved. Unfortunately, very often when both sides are involved, they clash, and it can be problematic, and the client, the tenant customer needs to be well organized to have both the IT and the real estate sides working well together. The other thing that has changed, as Kevin alluded to earlier, is finance has become much more involved. Frequently, the data center operations report directly or indirectly up to the CFO, and even if they don't report to him, he's much more involved, because these have all become issues of risk management and mitigation, because if you're operating a retail site and your data center goes down, you're out of business for the period your data center is down, unless you have a good backup that simultaneously replicates all the data and the operations and takes over instantly. So finance has become very involved in these transactions. Next slide. So the next issue I see coming up all the time are alteration rights. And this is an example of an issue where when I'm on the landlord, owner, operator, developer side, not the tenant, customer, user side, I see some of the problems that develop here as an example, because companies that are taking data center space may have their regular real estate lawyer handling the matter, or they may have their regular IT lawyer handling the matter, whether they're in-house or outside, and very often they don't have someone who's really experienced in data center transactions. And it could be a real estate lawyer who says, oh yeah, I've done millions of leases, including 2 data center leases, or an IT lawyer who says I've done millions of software and data-related contracts, and I can figure out a MSA, Master Services Agreement, for data center space. The problem is, as Kevin said before, these transactions overlap between real estate and IT and telecom and technology, and it becomes very difficult to deal with unless whoever's representing the counterparty in the transaction is knowledgeable specifically in data center transactions. So alteration rights are an example. A knee-jerk reaction of a real estate lawyer is, I want the right on behalf of my client as tenant customer to make alterations in our premises. But if you're leasing a turnkey, fully built-out data center space or racks of colocation space within another data center, in either of those cases, you're not putting up walls, you're not constructing things in the space, you're just installing servers, maybe racks, maybe cables and wires connecting the equipment and such, and you don't really need alteration rights, yet it comes up as a major issue all the time. Next slide. Transfer, assignment, and subletting rights. So very common to be dealt with in terms of the restrictions on the tenant customer in a lease. It's inverted, as many issues are, when you're dealing with a master services agreement. A master services agreement the concept comes out of the IT side, and when a transaction originates in an IT type atmosphere or a technology atmosphere, the document they're used to dealing with is typically a master services agreement, not a lease. And in fact, I've dealt with tenant customers where the IT or technology or telecom people say, I don't have authority to sign a lease, but I do have authority to sign the same document if the title is Master Services Agreement. The problem is that their expectations coming at it from an IT or telecom side are different if they're coming at it from the software or the services side, as Kevin indicated earlier. They will expect an agreement that doesn't restrict them as customer and instead contains transfer, assignment, subletting risks on the landlord, operator, service provider's side. So there's a conflict there that needs to be reconciled to make sure that the parties get the transfer rights that are appropriate and they're entitled to. For example, if you're doing a transaction in a multi-tenant large data center space and have one customer who's taking 5% or 10% or 20% of that data center space, if you're talking about someone who's looking at it from the IT MSA side, they might, as is customary in software and services type agreements, want to have a restriction on the service provider, the owner-operator, transferring and somebody else coming in and providing services to them. On the real estate side, that's not normal for there to be a restriction on the owner of the facility transferring. And that's a rub that has to be worked out and find the happy middle ground that works for everyone in the transaction. Next slide. So another issue that comes up regularly is the word reasonable or reasonableness. So conceptually, everybody wants everyone to agree to be reasonable. But there are different rules of the road in leasing transactions versus IT, software, MSA transactions. In a lease, the custom in the industry is that the document spells out the specific areas in which a party has agreed to be reasonable, and if they don't say it, then it's a sole discretion decision, such as a tenant wants to make alterations. It'll say minor alterations don't require landlord's approval, or the landlord agrees to be reasonable, but major alterations require approval, and don't say anything more, or might say in their sole discretion. Whereas in a master services agreement, frequently there is a catch-all that says both parties agree to be reasonable on everything unless they say that sole discretion is retained. Again, coming at it from a different perspective and different types of documents that need to be reconciled to the needs of the parties. Related issues are waivers of damages, which I'll talk about more in a minute, and remedies and how you use arbitration. In my view, I'm a big proponent of arbitration as a remedy to deal with these kinds of issues. Next slide. So power is another major issue that comes up more and more often. And as data centers have evolved in recent years, and as companies have become much more sensitive to the increasing cost of power and trying to control costs by getting an efficient operation in the data center, there's a shift away from older data centers, which have a PUE, power utilization efficiency rating, that's higher than a newer data center, which is more efficient and lower additional cost for the power above the base rent that you're paying for the space. One issue is a customer wants to be sure that the landlord, operator, service provider isn't building a profit component into power, and it's just a direct pass-through in addition to the rent or the service fees for the data center space. It also ties in to the quality of power and how much the facility operator is willing to guarantee that by providing an SLA, service level agreement, with assurance of redundancy and credits and possibly termination rights as a remedy for poor power quality. Next slide. Another less tangible issue that I see much more often in recent years, it is much harder to get a deal done, and it takes much longer. One of the components of that problem that I've touched on earlier is dealing with lawyers or business people who are not familiar with data center transactions and are out of their element. I had a transaction recently where a general real estate lawyer started representing the tenant customer and negotiating the data center lease opposite me. I was representing the owner operator. And they were a real estate lawyer, and there were a bunch of issues, particularly the SLA and service level related issues, where they said, our data center expert will come in at the end of the transaction once we've worked out 90% of the document, and he'll deal with these provisions. Great, I waited, we set those aside. What happens near the very end? They bring in a patent and trademark lawyer who had worked on 1 or 2 data center transactions and was also completely out of his element. And it just becomes really difficult doing a transaction when someone doesn't know what's reasonable and customary and what are standard compromises and middle grounds, which are the critical issues, which are not relevant or important to a transaction. Next slide. Data security and data privacy and data sovereignty are increasingly important issues. There are jurisdictions that have laws requiring personally identifiable information, private social security number, name, address, date of birth, that sort of stuff, to be kept within the jurisdiction in which the customer is located and provided the information. And that presents a problem when you have, for example, a cloud-based network of data centers, and if you're a customer with one of the major cloud providers, you don't know whether your data is being hosted in their data center in New York, Los Angeles, Singapore, London, Germany, South America, Antarctica, the moon, who knows? And you may be, and they may be, in violation of data sovereignty, data security laws by not maintaining the data in the right jurisdiction. There are also a whole host of restrictions here in the U.S. and around the world regarding data privacy, reporting for data breaches, HIPAA, confidentiality of information, and you've got to properly manage that, have people who are familiar with the issues and can deal with it up front. So, for example, one issue I've dealt with a number of times is I've done a couple of transactions with healthcare operators where their people have been told anybody we deal with has to sign a HIPAA Business Associates Agreement. But if you're leasing data center space in a data center facility where it's really a real estate lease with power and services or even an MSA, but not managed services and hosting where the data center operator is in your data. If you're just leasing space and the customer is putting in their own servers, the operator doesn't really have access to or control of your data and wants you to password protect and encrypt your data so they can't get access. If they sign a HIPAA Business Associates Agreement, it implies that they have access to the data and liability if there's a data breach. It's basically painting a big red bullseye on the data center operator saying, sue me if there's a data breach, when unless you're dealing with managed services or hosting, that operator really has no control over the data or access to it. The one narrow area that the operator of that kind of facility can and should have liability is physical security. Yes, if I gain access to your data center and walk in and pick up a server and walk out of the building with it, that is an area that the operator of the facility should have exposure and liability. But aside from that, it is typically unless it's managed or hosted services, the operator of the facility has no access to the data and shouldn't be signing a business associates agreement and shouldn't have data security risk. Next slide. Consequential damages and limitations on that. It's customary in the real estate world to have leases contain a limitation saying, if I make a mistake and do something wrong, I will be liable for actual direct damages, but not consequential damages, principally lost business. Whereas in the IT software MSA world, it's customary to have liability up to some greater number for potentially some specific areas of consequential damages. The principal ones that come up are breach of confidentiality and data privacy, indemnification issues for third-party acts, and sometimes willful acts or gross negligence. Next slide. So another area that has been rising in level of discussion and importance in data center transaction is those liability issues. Years ago, in data center leases, there was a complete waiver of consequential damages and a limitation on liability that narrowly limited the landlord's obligations if something went wrong. That has evolved as we've sort of moved towards a middle ground between leasing concepts and master services agreement concepts with a cap on damages, and the concept of each party has liability up to some agreed dollar amount, which is typically, depending on the size of the transaction, a couple of months of base rent or a couple of years of base rent for larger transactions, or a fixed agreed dollar amount, X millions of dollars, and both parties have liability, but there are issues that arise in negotiating those caps, and do you exclude from the caps, as I indicated before, issues such as confidentiality and indemnity and willful acts and gross negligence, and how does this all tie in to HIPAA type rights? The other issue that comes up is termination rights. That is a problem for an operator of a facility, because if they are going to be spending millions of dollars building out a space or customizing it for a customer and then have a risk of being terminated on short notice, it makes that transaction very difficult, if not impossible, to finance. Because it could disappear on a day's notice. The other related issue that comes up is, in particular, dealing with large hyperscale cloud providers as tenant customers of data center space. All of them use their own, for many, not all transactions, their own form, lease, or MSA. And the first draft of it that I've seen, virtually every single transaction, includes a termination for convenience, that the customer has a right to terminate at any time without a reason on 30 or 60 days notice. That's untenable for an operator that's sinking millions of dollars in and giving the customer a rental or service charge commitment for a fixed period, 5 or 10 years, usually with some fixed or CPI-based escalation, but the tenant's risk is capped and the landlord's is wide open because the tenant could terminate on a 60 days notice. Next slide. Now for the drum roll, next slide. My number one issue I see in data center transactions is, it used to be said, location, location, location is critical. Now it's optionality, optionality, and more optionality. Every tenant customer wants all different rights, and typically overlapping or conflicting rights. Both they want, on the one hand, the right to grow and take on more space and power, and on the other hand, to protect their downside and to reduce space and power, or a ramp up during the first 3 years that they take on power in stages and pay rent in stages that ramp up over a period of time. frequently want partial termination rights to give back space, multiple expansion rights, contraction rights, renewal or extension options, and a right when they exercise those options to not take it for all the space and power, but to use that as a point of contraction to take less for the renewal term than they had for the initial term, as well as rights of first refusal on leases, if it's a large transaction, potentially on a sale of the entire property, rights to take the last available power or space in the facility. The problem with this is it all makes it extraordinarily difficult for the owner-operator to project how much space and power is each customer taking so that they know what they have available to give to other potential customers, and you end up having situations where if it's not properly controlled and managed, the operator of the facility can have conflicting options and rights that they could end up being in default under agreements because they can't give everyone what they want if multiple customers exercise expansion or additional power or space options at the same time, and they've leased out 150% of the building or its power. I've dealt with those situations, and it becomes a serious problem. Next slide. So this is who I am. My number is here. It'll be on the website. If anyone has questions, feel free to give me a call or shoot me an email. Next slide. And that's the end of my presentation. Thank you.
Thank you, Jeff and Kevin. Great presentation. It's a hot topic right now, and we're getting a lot of traction asking this type of questions. So I hope that everyone I hope this presentation met everyone's expectations. So let's start with the questions. I see some questions. If you have any question, please feel free to go and write it in either in the GoToMeeting chat room or in the Skype meeting chat room. We're happy to answer all of your questions, and if for some reason we don't have time, we will address it individually. But let's start with the first question. I think it's a great question. This is something that many people are asking. Do you see enterprise and multi-tenant data centers disappearing and data storage and processing completely moving to the cloud?
So I see the world evolving, and 10 years ago, the hyperscale cloud providers didn't exist, and there was very little data storage and processing in the cloud. That has changed dramatically, and the companies that provide that space are growing exponentially. That service, cloud data services, are growing exponentially. However, the need for data centers, physical enterprise, individual customer, and multi-tenant data center are also growing exponentially. And I don't believe that they're mutually exclusive. I think there's a market for both of them, and both markets are growing so much that they will both continue. The older, less updated data centers are no longer feasible business operations or usable and need to be upgraded or mothballed. But a new state-of-the-art, recently upgraded or built facility, I think, has a very long lifespan as long as its operators keep it current. And there's room for both the exponential growth in the cloud and in physical data centers. Kevin, what do you think?
Yeah, I mean, the sort of solution that seems to be ubiquitous now for my larger clients is consolidation into some very, very low number of owned data centers, which have, as you said, Jeffrey, either been recently renovated or we will renovate them to increase power density. So as an example, they would go from many down to one or two, if we're only going to talk about continental U.S. as an example. Use of colocation facility for regionalization, replacement for some of the more regionally directed facility requirements. So they'll have 2 or 3 or 4 facilities in a colo. Those colos handle edge requirements, so they're in geography out to those applications that are trying to handle that. And they will have as I said during my discussion, a pipe out the back end, a high bandwidth to a cloud service provider, and they will dynamically use that as a hybrid environment, so they have private and public cloud capabilities in and out. So the enterprise data center in itself is not dead. I think you're going to redefine the enterprise data center as a combination now of some owned facilities, and usually many of them are quite large and quite capable. And they retain them for all sorts of reasons, both legal and structural and security requirements. And then the use of co-location as data centers, not just a single. I'm finding that it turns out to be multiple sizes. So they'll 2 or 3 larger, facilities, maybe several small, just racks around it. And as I said, add a few of them, a pipeline up to the cloud to dynamically handle that. And that more or less design, if you have that in your head from my verbal, description, seems to be a pattern that is developing the last 2-3 years and continues.
So one other issue I didn't mention on that point is what a customer is willing to do has a lot, whether it's needing to own physically their own enterprise data center, or are they willing to be in a multi-tenant data center operated by a third party, or are they willing to move partially or completely to the cloud? A lot of that comes down to control. And some companies have a need or a desire to have complete control over the facility. And as you go along that spectrum from an enterprise-owned facility to a multi-tenant leased facility to the cloud, you lose control at each stage. And if the company wants complete control, to add more security if they want, to change the biometric locks on the doors, to upgrade the cooling system, to add water-cooled racks, whatever. It's harder to do that as you go further along that spectrum away from an owned data center.
That's a really good point, Jeffrey. There is also the rise of what I call boutique co-location providers. So unlike the providers that are traditional that we all know, that have a combination of retail, open cage or segmented cage, and some wholesale where it's walled off and you have a suite. There are co-location providers now, and many of them, that will do build to suit. And essentially what they'll do is have a large building and they will build suites only. It is, as Jeffrey said, multi-tenant, but it's far more secure than a standard multi-tenant environment in a standard co-location provider. They will allow you to customize that space to a much greater extent than you would in a sort of standard colo offering. What they're essentially doing is they are building you a custom data center. It turns out to be a financial transaction. They're going to own it. You lease it as as if they were a standard provider over a long period of time. And there may be a couple of other tenants, highly segmented in that facility or not. The building, depending upon your requirement and your scale, you could be the only. And so that rise of these boutique providers provides a sort of interesting in-between, what Jeffrey was referring to, full control owned, slightly less control to a boutique, and less control when you go to the sort of standard operators.
Thank you. I have a couple of interesting questions came in. How long does it take on an average to go through a colocation search and contract negotiation?
I'll leave Kevin to answer the first part in terms of the search.
Let me see. My retirement date is coming up. No. So there's two halves, and if you listen to what I went on ad nauseum in the beginning, depending upon the scale of what you need, if you don't have the data that you need to do a search, then that can take some period of time. On average, we can generally carry out a median level strategy in a 8 to 12 week time frame, which would also include in that time frame the ability to issue RFIs to co-location providers to be able to bring some of that data in and shortlist. And one of the ways that we do the RFIs is we issue, this is just a technique that we've used, we'll issue RFIs to providers as EYP for private client. And what that does is it shields the client from having the public understand that they're looking for co-location capabilities. And that can be very important depending upon your brand and your image and the geography and HR issues. And when we do that, the colo operators know we have a client and we get good numbers in the back. And that can allow us to go from 5 or 6 potential operators in a given geography or even a shotgun spread across the U.S. down to 2 or 3 of the most likely candidates, which then once you've received that data and done some work and sold it internally and have a concept for what the contract structure needs to be, you issue an RFP, which is an update to the RFI, which has a greater degree of detail, and that allows you to close that RFP down much, much quicker. The unknown is what Jeffrey's going to talk about.
Hard to predict how long a transaction will take. It's sort of like getting into a taxi and saying drive, and how long will it take me to get there? But you haven't told the driver the route you're taking or the destination. It's very difficult to predict. I've done transactions in a couple of weeks. 2 to 4 weeks is an extraordinarily fast-paced transaction. Depends on the size of the transaction, who the other parties are, how sophisticated they are. Do the players know each other, and have they been through transactions together that they can shortcut things, or say, we'll work off this pre-negotiated document from another transaction. But as a rule of thumb, I'd say if you're talking about a data center lease or MSA of a decent size, say 250 kilowatts up to a megawatt, you're talking at least 1 to 2 months, possibly 3 to 4 months. If you're talking about a larger transaction over a megawatt, more likely the 2 to 4 month range. But again, I've done transactions in much shorter periods, and I've had transactions that have sort of started and stopped and taken 6 to 12 months to get done.
And I'm going to add to that on the front end piece for a second, and it's also going to be an unabashed plug. So I apologize to everyone because I generally try and stay away from it. If you use a consultant that knows the co-location market and knows co-location operators and knows facilities and has walked through the majority of their facilities, hint, 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 that time frame gets shortened because their understanding of what you need and what's out there rapidly allows them to recommend who the operators are and even specific facilities to go target based on what you need. More importantly, it's not just the operator, it's the space that is available within the facility. And I try and get people to understand that every piece of potential leasable space in a co-location facility is not necessarily the same. Depending upon the occupancy of that facility, some of the space may not be well suited, meaning it's so chopped up or so badly put into a corner that it reduces the usability of the space. Or if you have security requirements, the inability to create the kind of envelope that you need may be there. So it's not just the provider, it's what the space is that is in that given facility. And so oftentimes we'll recommend a particular provider and possibly 2 or 3 of their facilities because we know that those facilities are popular and that they have some difficulty in finding the amount of space that you need. As I said, not all space in every facility is equal.
Those great answers. I would add to that also that someone like Jeffrey, with all his experience, sometimes it's easy to negotiate a contract when he already understands either the client or the colocation provider, and he has done negotiations and speak to the different lawyers. So that would probably expedite the process. Another question, and we're getting a lot of questions, so I make the decision probably a little bit egotistic for those who have not had lunch yet, but I'm gonna let maybe 5 or 10 more minutes in the call for those who wants to remain. If not, this conversation will be recorded, so you can still come back and listen to the answers. So, well, this is an interesting question. Who typically pays for business loss recovery insurance that covers the revenue lost by the tenant in the event of a downtime? The landlord or the tenant, or does it depend on who is deemed to be at fault?
That's all yours, Jeffrey.
So you need to segregate that. Thank you, Kevin. You need to segregate that because there's a couple of overlapping concepts there. So one part is the rent payable under the data center facility lease or master services agreement. And there are two sides to that from an insurance perspective. The landlord, owner, operator will want to carry rent interruption insurance so that if its rental stream is interrupted because, for example, there's a casualty, hurricane comes in and damages a portion of the building, or a fire or a flood or whatever, and they're not collecting their rent because there's a rent abatement under the agreement because the tenant customer can't use the space. The landlord should protect itself by having rent interruption insurance. On the other side of that same equation, the tenant customer should have business interruption insurance. And the two types of insurance don't necessarily mesh. So the tenant wants that interruption insurance to cover its expenses if there is a bad event. So if that hurricane comes in and the tenant can't do business because of it, it should collect on its business interruption insurance in part to be able to pay its rent to the extent it's not abated, but also to be able to pay salaries for the employees who would otherwise have been working in that space, and they can't work because the space is closed from the hurricane damage. Yet they're still on payroll, and you don't want to lose them, and you want them to be available 2 weeks or 2 months later when the facility comes online, so you have to pay their salary. That business interruption insurance covers all those kinds of things. You go beyond that, and there are various types of errors and omissions and data-related insurance products that you can buy as a tenant customer. I have to tell you, they aren't perfect, and there's a big gap out there that you can't, as a customer, really insure all of the risks that exist in operating a data center facility. So the bottom line of all of that is you need a really good insurance consultant or broker to make sure, whether you're on the landlord, owner, operator side, or even more so on the tenant customer side, to make sure to put together a good package of insurance coverages that minimize the areas, the gaps that are not covered. But unfortunately, it's not perfect. I've been talking for a number of years about trying to create a better insurance product, and it just doesn't really exist today.
Jeff, to continue with that answer, how often do you have to deal with unlimited liability?
We see requests for it from time to time. Sophisticated parties rarely request it nowadays because the custom in the industry has evolved that there is rarely unlimited liability. So I would say in transactions I see a request for it on a broad basis 5% of the time. Unless you're dealing with someone who's completely unsophisticated and doesn't know the custom in the industry, and that's where the 5% comes up usually.
Thank you. Kevin, what impacts do you anticipate from evolving technologies such as 5G, IoT, and edge compute on the colocation market?
So let me do that in reverse and help me go through the list. So edge, I think I mentioned just before, and I have to apologize in advance to everyone. The definition of edge computing is so broad now. So I'm just going to use my own, definition in my mind. We have clients who, instead of trying to service their edge apps and clients from sort of larger, centralized, less distributed data centers, are contracting with co-location providers who are very happy to do this for essentially very small space, a couple of racks. For their edge node, and putting them as close as they can to the client or the geographic need, if in fact it's a geographic need. And so people think about turning to co-location providers, getting large amounts of space, but you don't have to. You could turn to even the traditional providers and say, I have an edge frame that I want to put in with an app, and it covers this geography or multiple geographies, and literally all I need is this very small footprint, but I need it in, I'm making numbers up, 10 locations, 10 of your locations around the U.S. They're perfectly happy to engage that and perfectly happy to put a centralized contract together to allow that to occur. And that allows you to not have to maintain your own space, have it in a managed, so to speak, location, and put small frames out in those spaces. Also, if the data coming back needs to hit a cloud provider to be able to reference it, you can do the same thing. Many of these operators will give you small frame space, will also provision you to have a bandwidth out the back door up to a public or private cloud arrangement that you have with a cloud provider to hit that database. So what were the other two? 5G. So 5G deployment is going to take some period of time. It's right now the sort of same marketing thing that cloud was, 6-7 years ago or more. It is slowly being rolled out on the user side, our cell phone side. It is slower to roll out on the commercial side. It has great potential. And as it stands right now, for the next couple of years, I do not think that 5G is going to supplant the requirement for co-location or owned data centers, although it may eventually change the way you build a data center and how you provision it, how you even build out and network your own office space as well as data centers. So I could paint a picture of how it would change everything that we know, but the problem is the speed to roll out the basic tenets of 5G is going to get supplanted by the increasing capability, and 5G capability are going to leapfrog themselves quite rapidly for anyone to make a large capital investment up front. So
let me just
have minimum. Go.
Interrupt and add a little bit to that, because I agree with what Kevin said about both Edge and 5G. 5G, just to take a step back, if you go back to when 2G, 3G, and 4G were rolled out, they get announced, the companies make a big marketing blitz, but in reality it takes several years before the technology is really out there and accessible to all of the consumers in a big way. That's exactly what's happening with 5G. A lot of the carriers are indicating that I have 5G. Well, the reality is, yes, they do. In a test 5, 10, 2 test markets where they've set up a few 5G antennas. The problem is 5G is just starting and there are not yet uniform standards in the industry. So different carriers are using different means, different radio frequency spectrum to provide 5G. Much of it is being done in higher frequency spectrum, which is less crowded and gives you the ability to transmit data in higher volumes and higher speed, but has one major defect, or two. It has much shorter distances that it operates, requiring many more antennas closer together than current 4G cell sites, and much of that technology doesn't penetrate buildings or even a sheet of cardboard. So the reality is you have a huge investment in building out these networks that will take time to really roll it out on a big way. So in my view, 5G, we have to all prepare for it, but the reality is we're not going to be using it on our cell phones for at least, my prediction personally based on what I've heard, is at the earliest 2021 in some jurisdictions, and more likely to have it broadly in operation in major cities 2022.
Great, thank you.
And they accuse you of just being a pretty face, Jeffrey.
So 2 more questions to go, one for Kevin and one for Jeff, and we're ready to go. So last question for Kevin, what is the average power density per square foot that you are seeing today?
Oh, good Lord. It's all over the place. Standard enterprise, 10 kW. It can go much low. I mean, the reality is when we have clients come and tell us what they have, when we go and look at their existing footprints, a lot of them are down in the 3, 4, 5, 6. Our recommendation always is to do build outs in most colos or provision to at least handle 10 to 16 without potentially breathing hard if you need that. If you have a requirement for high performance computing, which is a completely different world, and many of you may not, at this point that can go anywhere from 30 kW up to 60 or greater, depending upon whether or not the colo provider can handle either full standard containment or has water cooling available and can handle that. So it is all over the place, but the majority of our enterprise and small clients fall somewhere between the 7, 8, 9, 10, and 12 brackets, somewhere in there. And most colos look to that, but they can quite easily go up, higher than that, quickly up to 12 to 16 if necessary, without making too many provisional changes.
So I would just add to that one issue to bear in mind is what is the distinction between what are people asking for in the lease or the MSA versus what are they actually utilizing. Mm-hmm. And in order, the natural tendency of people, including data center engineers and designers and customer utilization people, is to want to cover yourself and not get criticized later that you didn't get enough power density in the space or enough available capacity in your lease or MSA, and to hope for the best, plan for the worst, and make sure you have enough available to you. So in my experience, you see documents that provide for a huge variable range as to capacity and density, but the reality is customers are actually using a fraction of that, a third or a half in my experience generally, and they may need more of it in the future, but they don't want to be in a position that if they need it, they don't have it available.
There was a study done 2 years ago of precisely that in a select number of co-location providers, and what they found was that clients were actually using 60% or less of the contracted access to power that they had signed for.
What happens in the opposite case, where they sign for 7 kilowatts rack and they needed 10 kilowatts per rack?
I mean, co-location providers are always happy to give you more. And remember, it's not really space that you're leasing or renting. It's really access to power. And so if they can't bring it into the physical space that you have, if you have contiguous space, which means I don't really need the space, but I need the power, so I'm going to rob it from the space that I'm going to lease. That's one way of doing it. You may have to move within the given facility, or work with them to bring an additional level of power, which means additional level of cooling into the given space. And remember, it's not just the access to the power that is that density. They may be able to bring the power in, but they may not be able to cool it effectively or efficiently from a cost standpoint. So there's a little bit of engineering work that needs to be done in advance to understand precisely what it is that you need.
So one other point on that is that ties back, this issue ties back to the beginning of Kevin's presentation in terms of talking about planning ahead. What are your real needs going to be so that you make sure that you accurately project as best we can, because the world is changing at light speed and it makes it very difficult to plan ahead. But that gets back to properly planning ahead so you have a ramp up or expansion options or contraction options that deal with the best guess today as to what the needs are going to be in the future, so you're not paying for more capacity than you really use, but have the ability to get that capacity if you need it. The other thing that ties into that is once you sign your initial agreement, if you don't have those expansion options or options to get additional power and space, and you go back to the operator of the facility and ask for it later, in all likelihood, you're not going to get the competitively negotiated pricing that you got in your original deal, and you're going to be paying a premium because you came back later for something additional. They'll be delighted to provide it to you, but it won't be necessarily at the same rate if you don't have the right to it in your agreement.
Thank you very much. Last question, and we're good to go. And I apologize again for remaining here, but when you get an intelligence audience that asks great questions, it's better to answer them. So time to contract, it's more in line with the client's needs. What compelling event, compliance, technical, etc. Most data center providers are ready to contract as quickly as the client is?
Sure, they'd want to sign the contract tomorrow, and they'll hand you their standard form, and if you sign on the dotted line, you get it tomorrow.
Yep.
But the reality is, who drafted that agreement? The party that drafted it to protect themselves. And the same is true in reverse. If a customer shows up, as the hyperscale cloud providers do with their form agreement and hand it to you when you're the operator, it's going to be protecting that party. And the larger the transaction, the more important it is to the company. Data centers being mission critical facilities, you need to make sure that the agreement accurately reflects what the business deal is and gives each party appropriate and fair legal protections in the documentation. So that takes time. It doesn't happen overnight, and it involves a negotiating process and back and forth. That's what takes time.
Thank you. We would like to thank you for attending this webinar. Should you have any additional questions or would like to schedule a one-on-one with Kevin or with Jeffrey or one of our teams, please don't hesitate to contact us. Please visit our webinar page where you will find multiple topics relevant to your day-to-day experience. If you have any topic that you would like us to address in the future, please call us or send us an email. This webinar, it's being recorded and will be available to you next week. Again, Jeffrey and Kevin, thank you so much for your time, for preparing this content. I think it's been a great topic, different than the ones that we usually see. And I'm hoping that we have another one of these sessions in the near future.
I also want to thank David for pulling this all together and Kevin for being a great partner in this presentation. Have a great day, everyone. Thank you.
Same here. Have a great day, everybody.